Good morning, Mr. Kennedy. Good morning, everybody.
Good morning, Chair.
Good morning.
Are we ready?
We're ready with the next witness, and
Yes.
we would ask your leave to call him.
Yes.
His name is Mr. Tlib, T-A-L-I-B, Sadik, S-A-D-I-K,
Yes.
and he is ready to take the oath.
Okay. Please administer the oath of affirmation.
Please state your full name for the record.
My full name is Mr Tlib Sadik.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence will give you the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Good morning, Mr. Sadik. Yes, you can take off your mask. May I just ask you, when you give evidence, can you please try and speak in a clear voice? And try, I know it may be difficult because I'm asking most of the questions, although the chair may also ask some questions of you. But even when I'm asking you questions, try and look towards the chair rather than me,
Okay.
so that you show him the respect, so that he can hear you, and also so that your voice is directed into the microphone. Okay? Thank you. Mr. Sadik, is it correct that you've furnished an affidavit at the request of the Commission?
That's correct.
Now, you should have in front of you a bundle that is marked Danelle Bundle 11 and another one, Bundle 12.
That's correct.
And if I can take you, I've indicated to you already where you should be looking for the page number. It's the top left, the last digit of the numbers on the top left. Page 4. Is that the first page of your affidavit?
That's correct.
And may I ask you please to turn to the last page of the affidavit before your annexures at page 60.
Yes, I have it.
Is that your signature, the first of the two signatures that we see on that page?
That's correct.
Is it correct that you signed this affidavit swearing the oath before a commission of oaths?
That's correct.
And I note that the affidavit was signed on the 9th of February 2020. Is that
Correct.
right?
Yes.
Now, you've indicated to me in consultation that there are that there's one correction that you want to make to a word in the body of the affidavit. I'll take you there in a moment. But there are also some events that have changed since you signed the affidavit in February 2020. Is that right?
That's correct.
And I will take you through the events that have changed to the extent that's necessary. First, to deal with the correction of the word that is wrong, if I can take you to page 6, paragraph 152, you indicated to me that there's an error that you want to correct there. What is the error?
The error, it's paragraph 152 reads final report when it should read draft report presented by Ngidi.
Right, thank you. Now, apart from that correction, or subject to that correction, and apart from the events that you want to update the chair on that have occurred since February 2020, does the affidavit contain facts that were correct at the time of February 2020?
That's correct.
Can you confirm that?
That's correct.
And can you confirm you have been through this affidavit and you're able to attest to that under oath that all of the contents subject to the correction of that word that you've just indicated are true and correct in every respect?
Correct. Agreed.
Thank you. Chair, I would then ask, may I just indicate, Chair, that the witness has agreed to assist us further in providing a supplementary affidavit that formally corrects the error in paragraph 152 that he's alerted you to, Chair, and also to update you on the specific changes. It largely relates to the different role that Mr. Sadik is now playing within Denel. And he will provide that supplementary affidavit. And his attorney, I should have mentioned, he is assisted by his attorney, Mr. Pillay, who's been here on previous occasions in the
Yes.
Denel stream evidence, and we appreciate his cooperation as well.
Yes, yes.
So-
Well, let's just get him to place himself on record properly.
Thank you,
Mr.
Chair.
Pillay. I think just put on that mic. I don't know if it's working, failing which you can go to the one.
Good morning, Chair.
Good morning.
My name is Yugesh Pillay again. I confirm what Advocate Kennedy has transmitted to you this morning.
Yes, no, thank you, thank you.
Thank you, Chair. May we then, on the basis that's already indicated, ask your leave, please, formally to admit this affidavit, which is accompanied by many annexures. So that's the affidavit that appears at Denel Bundle 11 from page 4 as Exhibit W26. In fact, I beg your pardon, it in fact appears in both bundles 11 and 12 as one affidavit with numerous annexures.
Yes.
May we ask for leave to admit the entire affidavit as Exhibit W26?
Yes, the affidavit of Mr. Tlib Sadik, starting at page 4, with its annexures which go up to Daniel Bundle 12, is admitted as Exhibit W26.
Thank you, Chair. And with your leave, may I lead the witness on the initial issues that appear to be
Yes.
uncontroversial?
Yeah.
Thank you, Chair. Mr. Sadik, you set out in your affidavit the background that you have in relation to Denel. May I just ask you, before we get to that, what is your overall background by way of qualifications and by way of experience before you became involved in Denel?
Chair, I am a qualified chartered accountant. I studied at the University of Natal and I completed my CA exams. I qualified as a CA at around 1991, and since then I've been mainly working in a corporate environment, occupying senior finance roles, and the role that I had occupied for a time at Denel was the Group CEO. So I have over 20 years experience.
Right, thank you. And when did you first start at Danelle as an employee?
I started in Denel as an employee in 2006, as the Group CFO in 2006, and then in September 2018, I then took over the role as the acting Group CEO and was confirmed in September 2008 as the Group CEO of Denel.
And was that before Mr. Saluji was appointed as Group CEO?
That's correct, Chair. He had replaced me.
And when was that replacement?
He had replaced me effective from 1 February 2012.
Right. So you were either acting or as the fully fledged, as it were, GCEO for about 4 years, 4 or 5 years. Is that correct?
That's correct, Chair.
Right. Did you then leave the employ of Danelle when Mr. Saluji replaced you as Group CEO?
That's correct, Chair.
And were you then on the board of Danelle as you left at that time?
No, I was not on the board of Denel at the time.
But you later joined the board of Danelle. Is that correct?
That's correct. I rejoined the board on an interim basis in April 2018, and it was confirmed a month later. So I'm now part of the current board of Denel.
And that is the current board of Danelle under the chairpersonship of Ms. Schlachler. Is that correct?
That's correct.
Right. And we've heard evidence from her and others that the board, in fact, started operating fully from about May 2018. So you were there from the beginning of the new board, the current board's term. Is that correct?
That's correct.
Right. Now, in addition to, were you an executive or non-executive member of the Denel board then?
At the time, I was a non-executive director on the Denel board, and I was also appointed chair of the audit committee.
Is that the Audit and Risk Committee? Is that
It's,
its full title?
no, it was called the audit committee.
I see. And so you chaired that. What is your current situation in relation to Danelle?
Currently, from effective 15th August, I have been appointed as the interim group CEO, and I'm an ex officio member now of the board. I'm still a member of the board. I am no longer the chairman of the audit committee.
Because you are now acting or interim group CEO, is that right?
That's correct,
Yeah.
Chair.
So it's really a role that you previously served in, Group CEO. There was then quite a gap. You then came back to Denel in a different capacity as a non-executive director and as chair of the audit committee. But now you're back in the hot seat, as it were, as interim GCEO. Since August, you mentioned, I think, 18th of August. Is that of this year?
Yeah, 15th of August from this year, yeah, 2020.
Right, thank you. Who is the current chair of the audit committee?
The current chair of the audit committee is Ms. Siatola. She was part of the original board that was appointed in April 2018, and she's now taken over the chairmanship of the audit committee. We've now combined it with the risk committee, and it's now called the audit and risk committee of the board.
Right. Now, in your affidavit, we're obviously going to focus only on some specific points that appear to be of particular concern. You set out a number of facts which appear to fall, if I understand your affidavit correctly, and please correct me if I'm wrong, into two categories. There are some facts and events that you were personally involved in. For example, you deal with certain transactions that occurred while you were Group Chief Executive Officer. Is that correct?
That's correct, Chair.
The other category relates to some events that took place while you had no role at Danelle. For example, contracts that were entered into while others were involved in management, particularly Mr. Saluji, was in the role of Group CEO. Is that right?
That's correct, Chair.
And it appears from your affidavit that you have dealt with those issues, even though you don't have personal involvement in them or personal knowledge of them. You were asked by investigators because at the time that the request was made, you were sitting on the board and the chairperson of the audit committee to address. Is that right?
That's correct, Chair.
And in that regard, in that second category, you have referred us to, or the chair, to various reports that were the product of investigations done by various entities. Is that right?
That's correct, Chair.
Now, you refer at page 6 in your affidavit to reports that you received from various entities. So 151 refers to a draft report from Denton's, dated the 20th of January 2016, and that dealt with the acquisition of DVS, previously known as Land Systems South Africa, also abbreviated to LSSA. Is that right?
That's correct, Chair.
And then you've corrected the word final to read draft in 152. There was a draft report prepared by Ngidi, NGIDI, Business Advisory, dealing with the review of the process relating to the conclusion of the MOA between Denel and VR Laser. Now, you've indicated to me that it was in fact only a draft report, as the correction indicates, but has there ever been a final report submitted by Ngidi?
No, there hasn't been a final report.
Do you know why?
Yeah, Chair, we have made contact with them because this draft report that we have does not contain any annexures, although the main report referred to annexures. So we've approached them, and they've indicated that they no longer wanted to be involved in the Denel, to complete the assignment.
Right. Now, but have you furnished to the Commission whatever you have received from Ngidi?
Yes, Chair, we have.
Right. Now, to go back to the Denton's draft report, has there been a final report in relation to the Denton's investigation?
Yes, Chair, we did receive a final report, which was presented to the Audit and Risk Committee and then presented to the board on Tuesday, this past Tuesday, which would have been the 9th of November.
The 9th of November, this week?
Yes.
Right. And so what is the status of that? You've received that report. Is that now the subject of consideration?
That report, Chair, was considered by the board on the Tuesday, and it was noted by the board and referred back to the Audit and Risk Committee for the consideration of the remedial action to be taken.
Right. So does that still have to be then considered and decided upon, any remedial action that may be appropriate?
That's correct, Chair.
Right. Now, you've referred then in paragraph 153 to another report from a different entity, BDO PS Advisory. We can refer to it simply as BDO. They have submitted a final draft report on an investigation into inter alia non-adherence to policies, procedures and legislation by employees of Denel, Corporate Office, Denel Land Systems, DLS, and LMT, as well as DVS. Now, is that still at the level of final draft report? Is it a draft, or is it a final report, or is it a final draft?
It is a final draft report, Chair, that has been approved by the board. The reason why it remains a draft because of the limitation in the information that's available, but it's been approved by the board.
Right. And you've attached to your affidavit, as you say at the top of page 7, a copy of the BDO report, but not the Denton's and Ngidi reports, because, as you say, you don't want to make what's already a very large volume of paper even larger, but you have offered to make that available to the Commission. Is that right?
That's correct, Chair.
Right. Now, you've also referred in paragraph 1.9 to Price Waterhouse, a PwC rather. What did they investigate?
Chair, they had investigated the loans that was granted to LMT over the recent years, and we had asked them to investigate the process and the approvals process that was followed in granting these loans.
And you refer at the top of page 8 in paragraph 1.10 to the final report of PwC being expected. This is the time that that you're writing this, to be delivered at the end of January 2020, including recommendations. Can you give the Chair, is there any update to be reported on that? Has the final version of their report actually been received?
Chair, the report was received. It was considered by the Audit Committee. At the time, I was the chairman of the Audit Committee, and there were additional work that we felt the PwC should continue with. So they are now completing that exercise.
Then you refer in 111 to an investigation by ITI Act Pty Limited to assess the capabilities of Danelle's divisions to determine if the work listed in a particular paragraph could have been done internally to provide expert opinion. Now, are they the defence experts that are referred to in 1.12 of your affidavit?
That's correct, Chair.
Right.
Yeah.
And you say that was expected to be delivered by the end of February 2020. We're now in November. Can you give the Chair, please, an update on that? Have the defence experts known as ITI Act, in fact, submitted a report?
Chair, they have submitted a very high-level draft report, and we've been working through that. They haven't yet finished the exercise, and we have spoken to them recently to try and conclude the exercise. They've been having challenges on their side, but from our side, we've also been experiencing liquidity challenges, and we weren't able to meet the payments that was due to them.
Right. May I now deal with some of the specific transactions that are the subject of your affidavit? And we can start, if we may please, at page 9. Your paragraph 2 deals with financial assistance granted to LMT. And this, as I understand it from your affidavit, relates to an advance payment of approximately 12.7 million rand. Is that right?
That's correct, Chair.
The full figure, the exact amount is set out in your paragraph 2.1. Correct?
That's correct, Chair.
And this was an advance payment made by DLS, that's a division of Denel, is that correct?
That's correct.
To LMT. Now, the Commission has heard evidence that LMT was initially privately owned, but then a majority shareholding was bought by Danelle. And the evidence has been that one of the objectives was to acquire the capacity, production of capacity of LMT to enable it to be within the Danelle group so that it would have in-house capacity and would also be able to manage it. Is that your understanding?
That's correct, Chair.
Right. Now, as I understand your evidence, the 12.7 million advance payment was made before Danelle acquired the 51% shareholding in LMT. Is that right?
That's correct.
Now, when did this take place, the advance payment, and was it during the time that you were employed by Danelle as Group CEO?
That's correct, Chair. I was the Group CEO, and the payment was, the agreement was made on the 29th of April 2010.
Thank you.
And 28 June, as per clause 213.
Right, thank you. Now, did you as Group CEO at that stage approve the transaction in which the 12.7 million was paid as an advance payment to LMT?
Chair, we had a Denel Land Systems Divisional Board in place. I was part of the board at the time, and we had received a presentation by management, and part of the board, we had approved this transaction.
Right. Now, essentially, why was this paid? The other evidence that the chair has heard in the earlier days of these hearings to do with Danelle have suggested that it was not simply paying in terms of the contractual timetable for the provision of the goods concerned by LMT, but it was actually provided, as it were, as a benefit to LMT because they were facing some financial difficulties. Is that correct?
Chair, there were a combination of issues around LMT, and LMT, as I point out in paragraph 2.14, what caused us to go ahead, one of the issues was the financial challenges that the company was facing. But the important thing is that they were the localized partner of an international OEM called Patria. And we had then placed a contract on them called a Trunnion contract. And on that contract, we had paid 25% of that Trunnion contract as an advance payment.
Yes. But are the other witnesses correct to the effect that if you had simply followed the letter of the contract between DLS and LMT, you were not due to make that payment, but this was, as it were, a concession to LMT. It was a way of assisting them to get an advance payment which they weren't contractually entitled to, but which you were persuaded to pay in order primarily to assist them in a situation of financial difficulty.
Chair, when we place a contract, We normally will pay a supplier an advance payment, which is generally about 25% of the contract value. So it's on that basis we made so it was part of our normal course of business to make a portion of the prepayment, especially when a contract is quite material.
Now, you've referred to...
So, I'm sorry.
Sorry, Chair.
I take it that you are saying you dispute the evidence of those witnesses who said this payment of 12.7 million rand was a way of coming to the assistance in terms of it being an advance payment, giving assistance to LMT to assist it deal with its financial difficulties.
Correct.
I take
Chair.
it that you dispute that evidence.
I would say I would dispute it because it was based on a contract that we had placed on them, and on that contract we had given them 25% of the value of the contract.
You dispute it completely, or you say that consideration was one of the considerations and not necessarily the only consideration?
Chair, the latter it wasn't the only consideration, it was one of the considerations.
To assist them.
Yes.
Mr. Kennedy?
Thank you, Chair. In paragraph 218, you say that the prepayment was not precluded by any law, Treasury directive, or instruction or policy of Denel, and so you say it was therefore not unlawful to make the advance payment and not unusual commercial practice at Denel and the industry. You stand by that evidence?
That's correct, Chair.
Right. Then
So,
you...
I'm sorry. Earlier on you said something to the effect that advance payments were normal or are normal at Denel, at least were normal during your time. If you say they were normal, it might mean that they happened with a certain degree of regularity, frequency. They happened with a certain degree of frequency. It may mean that, is that what you intend to convey, or is the position that they were not a norm, but they did occur from time to time?
Chair, it was a norm.
They were a norm.
Yes.
Okay. All right.
Then in paragraph 219, you say this is ordinarily done in recognition that large manufacturing contracts demand a cash outlay and financial commitment, which a manufacturer may sometimes not be able to meet or unwilling to carry at full risk.
That's correct, Chair.
And in this case, were you satisfied that LMT was in a financial situation that it couldn't carry the risk up front? You would need to follow the norm. It was justifiable to follow the norm and make an advance payment.
That's correct, Chair.
Now, what seems to have been slightly different about this is apparent from paragraph 217. Normally, Danelle would seek advance payment guarantee from a bank on behalf of a supplier, but due to weak financial position of LMT, Danelle accepted alternate forms of guarantees. So are you saying that they weren't able to get a bank guarantee, which you would normally expect and require?
That's correct, Chair.
Now, you say that you accepted other forms of guarantees other than a bank guarantee. Can you recall what sort of guarantees were provided by LMT?
Chair, not in the exact detail, but it would have been guarantees over their assets, in particular their debtors book, and some of the IP that they would have owned as well.
Right. And some of the other witnesses have dealt in some detail with that. And do you confirm that after this advance payment, it happened that LMT's majority shareholding in LMT was acquired by Danelle?
Yeah, part of the arrangement to secure the guarantee, Chair, we had secured an option to convert our, well, really has security. So if we believe we need to get closer to the business, or it's an option for us to convert that into an equity, which is what we then did. At the time when we gave them the loan, sorry, not the loan, the prepayment, we had an option to acquire 70% of the company, and we then brought in another shareholder who came in as a consortium, and we then converted that option of 70% into a 51% stake in LMT.
Was the other entity that you brought into the consortium Pamodzi?
That's correct, Chair.
Are you aware that LMT, in fact, wanted to bring in a different entity as a triple BEE partner into the consortium, a company known as Beryl, B-E-R-Y-L? Are you aware of that? And that Danelle said no, they wanted rather to have Pamodzi. Are you aware of that?
No, Chair, I'm not aware of that.
Right. Now, you then deal in paragraphs 2.3 and 2.4 with advanced payments, an advance payment of 5.7 million relating to the Malaysian turrets contract in 2011, and a 378 million rand loan by Denel to LMT, which was the total of various individual loans. In respect of both, you say you have no personal knowledge of these. Is that right?
That's right, Chair. It happened when I was not part of Denel in any way.
Right. Now, well, was the Malaysian transaction not during your time? It says in 2.3 that took place in July 2011.
Sorry, Chair, yes, it was during my time, but I have no knowledge of that.
Right. And in the big
Yes.
amounts of loans to from Danelle to LMT, was that after your time there?
That's correct.
Okay. Well, now let's get to the next transaction, which is dealt with in paragraph 3 from page 14, and that is the platform hulls contract. And as you point out in 311, VR Laser was appointed with that contract in 2014 to provide platform hulls. Now, you had already left by that stage in 2012, correct?
That's correct, Chair.
So as I understand it, Mr. Sadik, you don't have personal knowledge of what went on, but what your affidavit then goes on, having been requested by the investigators to deal with this, it goes on to deal with what the BDO report then investigated and made findings on. And it is your affidavit section that starts here, a summary of what comes out of the BDO report.
That's correct, Chair.
Right. Now, did you say that the BDO report has been accepted by the audit committee
That's correct, Chair.
and the board of Danelle?
That's also by the board of Denel.
And did they make certain findings and recommendations?
Yes, Chair, the report did make findings and recommendations, which the board has, to a large extent, have followed through with those findings and recommendations.
Right. Now, can you indicate, just by way of brief summary, because there has been evidence in relation to what actually happened in this contract, and also the BDO report is an extensive report which you've attached. In fact, can I just ask you please to look at page 61, the first annexure to your affidavit. Is that the first page of the BDO report?
That's correct, Chair.
Right, and that runs, it seems, to 300 pages, and attached to the 300 pages in turn are a whole lot of annexures, correct?
That's correct, Chair.
Right. Now, can you just summarize in a few sentences, please, for the Chair's assistance, what the bottom line is of the BDO report's findings in relation to whether there was anything improper or unlawful done in relation to the awarding of the DLS contract for platform hulls to VRL?
Sure. So, Chair, there were three big contracts that were entered into with VR Laser, with the VR Laser Group. One was the platform hulls contract. The other was 2 memorandums of understanding. One of the memorandum of understanding was between Denel Land Systems, which was a division of Denel, and the VR Laser Group, and the other, which was the subsidiary of Denel called DVS, and there was a memorandum of agreement between VR Laser Group and Denel Vehicle Systems, which we abbreviate as DVS. So what the investigation found is that all 3 of those contracts were irregular. They hadn't followed proper process as specified in terms of treasury regulations and also in terms of the company policy of Danelle. And as a result of that, the report from BDO had recommended that we pursue civil, criminal, and disciplinary action against relevant individuals in the company.
Right. Now, when you say that there was non-compliance with the requirements of Treasury regulations and also Danelle's own internal processes, does that relate to supply chain management, procurement requirements of law, or does it involve other measures, or both?
Chair, it'd probably be I think a whole host of regulations. One in particular was around supply chain non-compliance. I think one may say it was also against the Constitution of South Africa as well.
Yes.
So it probably was larger than supply chain.
Right. Now, you then mentioned that action was recommended to bring criminal and civil legal proceedings as well as internal disciplinary proceedings against individuals. Would they be employees of Denel?
Chair, there were former employees of Denel, and there are some current employees of Denel that's been implicated as well.
Now, if I can take you please to page 24. And here we are dealing with the Hoefyster platform hulls contract. We'll get to the other 2 contracts that you mentioned in a moment. You appear to be summarizing findings from the BDO report that the closed tender process and signing off of the 7-year contract was non-compliant with the policy stated above, and it was irregular expenditure. And then you have referred to Mr. Berger in particular in 3621. He was the one who actually signed the MOA, notwithstanding having the knowledge that the Group SCM executive disapproved. And then Mr. Salucci as the ultimate approver of the appointment of VR Laser. Now, has any action been taken against these individuals at the level of disciplinary action?
Chair, no, we haven't taken any disciplinary action because they're no longer in the company.
Did they resign?
Both of them are. Mr. Berger did resign,
Yes.
and I think Mr. Salucci, his contract would have ended at the time.
Yes. In fact, he has given evidence to that effect. In fact, that was by agreement that he would then leave before the end of his contract, but would be paid out for the balance of the contract, or a major portion of the balance. Is that right?
Chair, I have no knowledge of that.
Were you not involved at the time that was done?
No, I was not.
Was that done at the time of the board prior to the board on which you served under Ms. Schlachler? Was it the prior board headed by Mr. Mantsha as chairperson?
That's correct, Chair.
Right. Now, you mentioned also the recommendation by BDO that criminal and civil legal action be taken. Let's deal with the criminal action first. 363 refers to action being taken by the current Chief Executive Officer of Denel. Who was that at the time you signed this affidavit at the beginning of February this year?
It was Mr. Daniel Mantsha, who was at the time the Group CEO of Denel.
And he has since left, is that right?
That's correct, Chair.
And was it Mr. du Toit that you then have replaced as interim CEO since August?
That's correct, Chair.
Right. So, Mr. du Toit, based on the recommendations of the BDO report, you say has taken action at the level of a criminal complaint under POCO, is that right? The Prevention of Organised Crime Act, in relation to this transaction. Is that right?
That's correct, Chair.
Now, are you aware of that because at the time the criminal complaint was laid, were you then chairing the audit committee of Denel?
That's correct, Chair.
Right. And have you, in that capacity, or since then as interim or acting group CEO since Mr. du Toit left, are you still monitoring that process?
Chair, we are monitoring it, yes.
And can you inform the chair, from your own knowledge, has there been any progress in the police investigation and has any prosecution in fact started to your knowledge?
Not to my knowledge, but there was a meeting held between the NPA and the Hawks on this matter.
And is Danelle cooperating with the Hawks in that regard?
That's correct, Chair.
Right.
We are.
Now, so you refer in 364 to the fact that Berger and Salugi have both left, so it was not possible to take disciplinary action. And then you refer in 365 to the investigation that we mentioned earlier. Apart from BDO, you also have had the investigation undertaken by ITI, I beg your pardon. They are the defence experts, is that right?
That's correct, Chair.
And that report is still not finalised.
That's correct, Chair.
And you indicate that that will consider whether or not Danelle suffered any financial loss from contracts with VR Laser, including the platform hull contract. So does their investigation currently underway, does that extend beyond the platform hulls contract and look also at the two single supplier contracts awarded by DLS and DVS?
That's correct, Chair. They're looking at all of the dealings between the Denel Group and VR Laser to see whether the work could have been done in-house, and also if it was outsourced, did we pay a fair market-related rates for that?
Right. And then you've indicated that once that investigation is complete and you get the report from these experts, ITI, that may be able to establish whether or not you've actually suffered losses, and if so, in what sort of amount, and will you take action potentially based on the outcome of that report once it comes?
That's correct, Chair, and that will form the basis for our civil action.
Right. Next, you deal from page 26, paragraph 4, with another contract that you've mentioned briefly in passing earlier, and that's the MOA between DLS and VR Laser. You mentioned earlier also a memorandum of understanding. The chair has heard evidence, and there's a lot of documents before the commission as well, which indicate that in respect of this transaction, there was initially a memorandum of understanding, and that was later converted to a memorandum of agreement. Is that correct?
That's correct, Chair.
And has the award and the conclusion of that contract, the MOA with VR Laser from DLS's side, has that also been the subject of investigation?
That's correct, Chair, and that was subject to the BDO investigation.
The DBO investigation?
BDO.
BDO, I beg your
Yes.
pardon. And you refer also to ITC Act, also looking at aspects of that. Is that correct?
That's correct, Chair.
Right. Now, this MOA specifically was a contract in terms of which VR Laser was appointed as a single supplier by DLS. Is that correct? That's your understanding?
Yeah, that's my understanding based on the BDO report.
Yes. And this was this for work over and above the platform hulls contract?
I would assume it's all the work that would have been required.
Right. Now, again, this was concluded, I believe, in 2015. Is that right?
That's correct, Chair.
And again, you were not involved either at management or board level of Denel at that stage. Is that correct?
That's correct.
So you can't help us with facts that come from your own personal knowledge about what happened within Denel with VR Laser in relation to this transaction.
That's correct, Chair.
Now, again, is your knowledge of information that you set out from page 26 based on what you have picked up from the BDO report?
That's correct, Chair.
Right. Now, again, may I ask you just in a sentence or two to indicate what your understanding is of the bottom line of the BDO report in respect of this particular transaction, the single supplier MOA between DLS and VR Laser. What were their overall findings and recommendations?
Chair, this was a single source arrangement when there were other suppliers that could perform something similar in South Africa. It was also quite a long contract. And
What was the period?
It was 10 years,
Right.
I think. Yeah. And the head of the supply chain at the time, according to the BDO report, had objected to entering into a long-term contract with this, and the management at the time went ahead and finalized the contract.
Now, you refer on page 29, paragraph 461. You in fact quote a passage from the BDO report which implicates Mr. Berger, Mr. Wessels, and Mr. Saluji in relation to the recommendation and approval of the deal in question, and that this was done irregularly in contravention of a provision of the National Treasury Supply Chain Management Guide, as well as the Denel Supply Chain Management Document of 2014, refers to the total payment of 107 million rand for, in particular, financial years, being irregular expenditure as defined by the PFMA. So is this what BDO found?
That's correct, Chair.
And have you accepted this particular finding of the BDO report?
Yes, we have.
Now, in addition to Mr. Berger, Mr. Wessels, and Mr. Saluji being implicated by BDO in their report in the passage I've just quoted from, you indicate in the next paragraph, 462, that the Ngidi report, which we know was never finalized, has also identified other people who may have been, who are implicated in irregularity. They too identify Mr. Saluji and Mr. Berger. We see that in 4621 and 462, correct?
That's correct, Chair.
And then it seems some additional people that were not identified by BDO but were identified by Ngidi. The top of page 31, Mr. Renan Turbis, correct?
That's correct, Chair.
Mr. Wessels had already been mentioned by BDO, but in 4625, Ngidi also made findings in relation to Zwelaki and Tsepe, correct?
That's correct.
As well as Ms. Denise Govender, the former Chief Legal Officer.
That's correct.
Is that right?
Yes.
Now, did BDO recommend that Danelle take any action, such as disciplinary action, criminal prosecution, and civil action arising from the irregularities identified in relation to this MOA between DLS and VR Laser?
Yes, they did.
Was that similar to what they had recommended in relation to the other contract, a platform health contract?
That's correct, Chair.
And have you accepted that recommendation, did you?
Yes, we have, and we've acted on it by reporting it to the police.
By reporting it to you?
To the South African Police Service.
So that, and do you know whether that is still being investigated, whether any progress has been made, whether there's any prosecution?
Chair, we are fully cooperating with them. We have a case number And there has been ongoing inquiries, and we've responded to that.
Yeah. Now, did BDO also recommend that you should take disciplinary action to the extent it was possible?
Yes, they have.
And was it in fact possible to take disciplinary action?
We at the moment are processing it and will continue with that.
Now, you say in 464, except for Mr. Tlib, and then Mr. Douglas Masuku and Mpolisi Makatini, none of the persons referred to in the reports are still in the employ of Denel. So presumably that is why you have not disciplined Mr. Wessels or Mr. Berger or Mr. Saluji, because they've left the employ.
That's correct.
Is that
Chair.
right? Yes. But what about the people who are still in the employ? Mr. Tlib, for example. Ngidi implicated Mr. Tlib in their provisional draft report, which has not been finalized. Has any action been taken against him thus far, and is any action possible?
At this stage, no action has been taken, but action is possible, and we intend doing that.
Right. Of course, under labour law, one is required to bring disciplinary proceedings quite speedily. Is there, I don't want you to be arguing any possible objections that might be raised in that regard, but can you just comment on why, firstly, when did you receive the BDO report? And why are you still in the process of considering whether or not to take disciplinary action against Mr. Tlib?
Yeah, Chair, the individuals that have been mentioned here are referred to in the Ngidi report, which was a draft report, and we need to, we were hoping to finalize that report before we could take action. In the BDO report, they've identified the individuals within Danelle, but they did not specify these individuals.
Yes.
So the reference here is from the draft Ngidi report.
I have no doubt the citizens out there who know that public money is at stake will be interested in the level of accountability
Yes.
on the part of Danelle's management, its board, and people such as yourself. Are you able to tell the chair to what extent you may be addressing these issues that have arisen from these various reports?
We are addressing them to the extent we can, and we believe we're making good progress, but these are the outstanding individuals that we need to follow through. With some of them, they were charged, or there were allegations with them on other matters, which we then concluded the investigation on, and some of those individuals were cleared on those other matters. So we will now proceed with the next stage.
Right. You then deal from page 33. There's quite a long section in your paragraph 5 that is headed the Arms Corps Hoofeistre contract, and specifically the procurement process followed in contracting Patria for the usage of its vehicle platform for the Hoofeistre vehicle variants. Was that also the subject of investigation by BDO or anyone else?
Chair, it wasn't really an investigation as such, but just more what the factual situation is.
Right. Now, you've set out in some detail the background and and you were asked specific questions. For example, if I can take you to page 37, paragraph 5.5, why DLS did not send personnel to Finland from LMT and or BAE, instead decided to capacitate personnel, etc. That's a question. Who raised that question? Was that a question from the investigators of the Commission?
From the Commission, Chair.
Right. So you were asked specifically to deal with these aspects. Now, I don't propose, unless the Chair would direct me to, I don't propose to go through this section.
Yeah, it's not really necessary because the report is there.
Thank you, Chair.
Yeah.
May we then turn to what seems to require some focus at page 46, and that is your paragraph 6, and that is Danelle's acquisition of LSSA, BAE, now known as Denel Vehicle Systems, a division of Denel. Now, there's been some evidence in relation to this transaction previously. As I understand it, and please correct me if I'm wrong in my summary, as I understand it, BAE is the British defence entity, correct?
That's correct.
And it owned a local entity that was referred to as Land Systems South Africa.
That's correct,
It
Chair.
was its South African subsidiary,
That's correct, Chair.
involved in defence item manufacture. Is that right?
Yes, that's correct.
And BAE then sold its shares in LSSA to the Denel holding company. Is that right?
That's correct, Chair.
Was that during your tenure as Group CEO?
It was not, Chair.
When did it take place?
It took place during 2014, Chair, and 2015.
Right. So again, are you simply providing information to the Commission at its investigators' request, and you do so on the basis of what you have been able to glean from the report of those who investigated it?
That's correct, Chair.
Right. Now, who has been investigating that?
There was a firm called Denton's.
Right.
The Denton's forensic investigators had investigated that acquisition.
Now, you mentioned Denton's right at the beginning of your evidence when we referred to the reports of various entities, and you mentioned that Denton's had given an interim report or a draft report, and that has now been supplanted by a final report. Is that the report that you received on Tuesday?
That's correct, Chair.
Right. So your affidavit, as I understand it, reflects a summary that you have made of the broad findings and recommendations of Denton's in their interim or draft report.
That's
Is
correct.
that right? Now, are you willing to make available to the Commission, if it requires it, the final report of Denton's?
Yes, Chair, the board at its review session on Tuesday agreed that the final report should be forwarded to the Commission.
Right. If you could please arrange for that to be done, if it hasn't been done yet. Now, we don't have that report in front of us now. I don't think we necessarily have to, because hopefully you can assist the Commission. Have you been through that final report?
Yes, I have been through the final report, Chair.
And had you previously gone through the interim report, which is summarized in your affidavit?
That's correct, Chair, I have been.
Now we're going to ask you in a moment for you to summarize the broad findings and recommendations from the interim report. Are you able to tell the Chair whether the final report in substantial material ways differs from the interim report?
Chair, it does not. Probably 95% is what was in the final report. That was in the draft.
Yeah. Is there anything in the final report that deviates in any material way from your summary of the interim report in your affidavit?
Not in a material way, Chair.
Right. Now, can you then summarize for the Chair, please, the broad findings and recommendations that come out from both the interim and the final reports of Denton's?
Chair, this investigation dealt with the acquisition of Land Systems South Africa by Denel. The shareholding base in Land Systems South Africa was BAE, which owned the majority stake, and then there was a local consortium called DGD Technologies that owned a minority stake. Danelle had acquired this company for about 855 million rand, and the findings from the Denton's report is that we had not fully complied with the approvals that we had received from the minister in terms of the conditions. In the one particular condition related to should the funding arrangements of the transactions become more onerous or become onerous to Danelle, Danelle had to revert to the minister to inform the minister on the change in the funding mechanism. And that did not happen. So the big part of the Denton's report focused around compliance issues to the PFMA They also looked at the strategic rationale of the acquisition, and they looked at the valuation of the business. Under compliance, at the time, Minister Brown was the Public Enterprises Minister, and her view, and Minister Nene, I think, was the Finance Minister at the time. And the condition that was put on is that Denel had acquired Land Systems South Africa through two loans that were arranged. One was with Nedbank and the other was with ABSA. And in the original PFMA application, the PFMA application process stated that the loan with Nedbank will be a 5-year loan. But in fact, once the acquisition was busy being concluded, Nedbank had changed the loan terms to 5 months as a bridging finance. So that was quite a substantial change in the funding arrangement. And in terms of the conditions that that Danelle had received in the PFMA, we had to revert to the ministers on the change, which we hadn't done.
Now, if I can take it to page 59, paragraph 6818, you refer in your summary of the interim Denton's report to a finding by Denton's that Mr. Saluji and Mr. Mshlontlo were responsible for these non-disclosures. And that in particular Mr. Mshlontlo, as the then group CFO, appears to have been primarily responsible for that. Now, has any action been taken against Mr. Saluji or Mr. Mshlontlo in that regard?
So, Chair, now that we've seen we've noted the report at the board, it's been referred to the Audit and Risk Committee for the remedial action to be taken. We have instructed senior counsel to review the report and to advise the board accordingly.
They, of course, we know, have left the employ of Denel some time back after they were charged, but ultimately not disciplined for various other allegations. So they cannot be disciplined now because they've long since left, correct?
They are no longer in the organization.
Yes. You mentioned that you're taking senior counsel's advice. You refer at page 60 in your paragraph 682, right at the end of your affidavit, just above where you signed it. You say the board has taken legal advice about recovery of any financial prejudice suffered as a result of the conduct of the officials identified. Danelle is yet to determine whether, and if so, how much financial prejudice has been caused to Danelle. It is when it is determined what amounts are recoverable from the implicated individuals that Danelle will institute such recovery legal process as is appropriate. Now, that of course was your affidavit as at the 9th of February 2020. Has there been any update to report to the chair of this commission as to whether Danelle has since determined whether you've suffered financial prejudice, and if so, how much?
Chair, in the final Denton's report, it highlights the interest differential during the bridging loan duration. So that has been included in the final report. But we're going to be engaging with senior counsel, who right now has been instructed, and to go through some of it has been reputational damage that Danelle has suffered, especially with the bankers that were providing the loans to the company, and also the way we funded the transaction. So we will go through that process. So it's still in progress.
My attention is directed to an aspect which I went through quite quickly, to do with the LMT prepayment. If I can take you back to page 11. What you've said in your affidavit at page 11, paragraph 214, is the decision to make an advance payment to LMT was made in recognition of cash liquidity challenges that LMT was experiencing at the time, and taking into account the importance of LMT, the localized partner of Patria, the timeliest delivery of hoof-Easter milestones. I'd just like to clarify, you used the term earlier that it was the norm at Denel and in the industry for advance payments to be made such as this. Presumably, if it was truly a norm that was uniformly applied, it wouldn't depend on whether LMT had financial challenges and whether you might be vulnerable if they were delayed by anything. You would automatically give them an advance payment. Am I right in understanding that it happened frequently, as you told the chair earlier, but not automatically? Is that right?
It generally would have happened automatically, because in the conditions one would say a percentage as an advance payment to a contract. And the reason why this is highlighted in the way it is that we had made available the advance payment without a proper bank guarantee. That was outside of the norm.
Right. And then in 217 at the foot of this page, the payment to LMT was intended to pay its business critical creditors to ensure LMT continue to operate as a going concern. To that end, DLS put in place measures that monitored the application or use of cash by LMT with a view to ensuring that the money was not applied other than for the intended purpose. Is that correct?
That's correct.
I'm sorry, that seems to convey to me something a little different from what I believe you said earlier on. The payment to LMT, that's still a reference to the advance payment, isn't it? Or not?
It's the advance payment, Chair.
Yes. Was intended to pay its business critical creditors to ensure LMT continued to operate as a going concern. That seems to me to say the purpose of the advance payment was to enable LMT to address its financial difficulties involving its creditors.
Chair, it was on the back of a contract that we had entered into with LMT, and we had paid them a 25%. What we did not do, Chair, is we did not specify when we gave a company a contract to use it for the particular contract. So generally, the funds of the supplier would have been pooled into their overall cash resources.
When you say what you have just said now, are you talking in general that whenever you made advance payments to any supplier, it was not specified in the contract for what purpose that payment was to be made?
That's correct, Chair.
That's what you say.
Yes.
Which in one way, at one level, could be interpreted as meaning that the supplier was free to use it in whatever way. Is that a fair interpretation? Or could that be a fair interpretation?
That's correct, Chair.
Now, that's rather strange to me, because whenever one talks of an advance payment in the context of two parties doing business, such as would be the case, I would imagine, with an SOE and a supplier, I've always thought that the advance payment, the purpose of the advance payment is to assist the supplier in carrying out or honoring its obligations under the contract. An example, the supplier undertakes in terms of the contract it concludes with Denel to deliver a certain product, to acquire and deliver a certain product to Denel by a certain date. That product is very expensive, and therefore it's agreed between Denel and the supplier that at least give me so much in advance payment, not the whole amount, but it's going to, the intention is to assist the supplier, in buying the product or making the product if they're supposed to manufacture a product. It's not supposed to, it's not that advance payment is not meant to be used by the supplier for other things and then fail to deliver in terms of the contract. So that would be that's my understanding of what the purpose of an advance payment is in those cases where it takes place. But from what you say, with Danelle, with regard to the advance payments that it used to be involved in, that wasn't necessarily the purpose. Is that correct?
That is correct, Chair. And just to expand on that, it was a similar policy with advance payments that we received from our customers, where we had put it into a pool account, and then we will decide how to use the cash. And that's been one of the lessons we've now learned, because if you look at where Denel finds itself today, we've used advance payments that we've received from our customers for other purposes as well, to fund our general working capital or to fund acquisitions, etc. So, for instance, if you look at the LSSA acquisition, there we had used an advance payment on the Hoefeister project to fund that transaction, to repay the loan that the bank had provided. So that's the lessons learned in terms of the turnaround that we are busy with right now, is to put in more stronger measures around that.
Well, it seems to me, and you must tell me whether you don't agree, it seems to me that it should be illegitimate to make an advance payment on the understanding that the supplier can use that money for whatever they like. If you are Denel and we enter into a contract, I must manufacture something for you, and you give me an advance payment, and I go and buy a nice Porsche or BMW with that money. Doesn't look legitimate.
Yes.
Would you agree? Why must I must wait and work for my money, get paid, then I can buy my Porsche or whatever.
Yeah, I absolutely agree with you, Chair. I stand to be corrected, but I think legislatively we probably need to tighten that up
Yes.
a bit more.
Because imagine if you take taxpayers' money and give me an advance payment, and I do exactly what I'm saying, go and buy a Porsche or whatever expensive car. The next thing when I'm supposed to deliver, in terms of the contract, I can't deliver because I don't have money anymore. Or that kind of thing. And yet you had given me advance payment. You understand?
I fully agree with you, Chair, and this is one of the issues that our current board has.
Yes.
You know, in terms of turning around, it's not only advance payments that we receive, Chair, or make, it's also payments that we receive from our customers right now.
Yes.
So what we've recently done, Chair, is that we've said, for instance, one of an essential service we provide is to the Air Force. So the Air Force pays us on a regular basis. So we have now ring-fenced the cash that we receive from the Air Force to use it for resources that's required to execute the Air Force's contract. Until recently, we did not do that. We were pooling the funds. So now we are also we are going further than just advance payments. It's also regular payments that we receive from our customers to ensure that they are being used for the contract of that customer.
Yes, okay. Mr. Kennedy?
Thank you, Chair. If I may, Mr. Sadik, conclude your evidence by raising an issue which is not dealt with in your affidavit. It was only raised in the affidavits of others, in particular Mr. Berger. And he has referred to the fact that you participated in television interviews, I believe on 2 occasions. Is that correct?
That's correct, Chair.
Just identify for the Chair, please, what the 2 TV stations were.
One was on ENCA, and the other was on the SABC Morning Live. On the ENCA, it was a program called The Fix.
The Fix. Is that with the journalist Karima Brown?
That's correct, Chair.
Now, Mr. Berger has complained about those interviews, and particularly the one on The Fix. Just tell the Chair, please, how it came about that you were interviewed.
Sure. Chair, we had made a parliamentary presentation providing an update on all of the investigations that we are busy with, and this in particular dealt with the creation of Denel Asia and the VR Laser Group as well.
Did you solicit the interview, or did the TV stations contact you?
We were contacted by the media.
Right. Now, what essentially did you say on ENCA?
On ENCA, Chair, the focus of the discussions was around the transactions with the VR Laser Group and Denel Asia. And the point we had stated is that based on the investigations we had completed, which was the BDO investigation, those contracts with Danelle were found to be irregular. And the recommendation from BDO, one of it was to pursue, a couple was to pursue civil and criminal action against the individuals. And that's what I had stated in that interview. And then the other question I was asked later on in the interview was who was on the board of Denel Asia. And on the board of Denel Asia, I had made the comment that they were, from the Denel side, it was Mr. Berger and Mr. Inchepe. At the time, Mr. Berger was the CEO of our DLS, and Mr. Inchepe was the group CEO at the time. And on the Denel Asia side, representing the other shareholder in Denel Asia, it was Mr. Van der Merwe and Mr. Singhala. I made the point that Mr. Van der Merwe was, I wasn't sure whether he was still the current or former legal advisor of the Gupta family. And I'd also stated in an interview that the other shareholder in Denel Asia was a company called VR Laser Asia. And these were Hong Kong-based companies. And the controlling share, or the 100% shareholder of VR Laser Asia was Mr. Salim Essa.
Now, Mr. Berger has, in 2 sections of his affidavit, alleged that you were misleading and defamatory in what you said in these interviews, that it was untrue. He's explained at some length in his affidavit, and he's going to be giving evidence as our next witness, so we'll be dealing with that. But he's given his version as to why he says the various transactions dealing with VR Laser, both locally in the DLS agreements, and also the VR Laser Asia and the Denel Asia venture, why all of those were above board and lawful. But what he has said is not only that you were defaming him by saying that he had acted improperly and unlawfully, but one of the main points he seems to make is this. I'm not going to take you to the affidavit, I'm just going to read out a few words that he uses. That he says that he considers these allegations to be defamatory and misleading, albeit part of a popular and yet irresponsible narrative in which it is suggested that Danelle was the subject of state capture. Then I might just have a moment, Chair. Just for the record, may I just place on record that that allegation is made in Mr. Burger's affidavit in Denel Bundle Volume 10, page 611, paragraph 11, and later in his affidavit at page 642 of the same bundle, Mr. Berger says again, I have previously averted to the statement made by Mr. Sadik, and that in its context is the statement you made in the television interviews, that Danelle has decided to lay criminal charges against certain individuals and will also institute civil action in order to record, it says, presumably he means recover, monies and losses suffered by Danelle. And this is the point I want to raise for your attention and reply, please, Mr. Sadik. He says it is no small coincidence that Mr. Saluji was not mentioned by name during the interview with Ms. Karima Brown on the television program The Fix on the 4th of August 2019. This is, of course, because Saluji trumpets the popular narrative. Now, Mr. Sadik, I'm going to ask you to comment on that, but before I give you that opportunity, I just want to indicate to you the overall thread of Mr. Berger's affidavit in this regard as we understand it. He effectively is saying to the chair of this commission that the allegations of state capture relating to Denel Land Systems, in which he was CEO, and he also had some role in relation to DVS to a limited extent as well, that all of these allegations that have been raised about irregularity have got nothing to do with state capture. It has nothing to do with any improper relationship between VR Laser and the Guptas, and improper relationship between them and anybody at Danelle, including himself. And in fact, as I understand his evidence, when we'll be asking him questions about this, he seems to be suggesting this, that the allegations of state capture are raised as a stratagem, as a ruse, as a pretext to try and deflect attention from the real reasons for Danelle being in such a serious operational and financial crisis. And that was bad decision-making and bad management of Danelle by those responsible other than Mr. Berger, and that people are trying to avoid responsibility, people such as Mr. Saluji himself. So he's saying that when you made these statements on television in the interviews and referred particularly to the Gupta connection, that you were being part of a campaign by people at Danelle to try wrongly to blame the problems being faced by Danelle relating to non-completion of projects such as Hoefyster, serious financial problems in which you've been and still are seeking bailouts from government, that all of this is just a pretext. And it seems that he's suggesting that you are part of this, and suggesting in particular that you are protecting Mr. Saluji by the fact that you didn't refer to him as by name, but you referred to others. Now that's a fairly long question, but I think you understand it was necessary for me to put that in context. Can you please tell the chair whether the criticism of you is valid or not?
Yeah, I think, Chair, it's really unfortunate to hear these points being made by a senior executive of the company. I mean, quite clearly, looking at the thoroughness of the BDO report, which we regard as being very thorough, and you would see there was a blatant disregard, not only the company policies within Denel, but for the broader South African legislative environment as well. And as a state-owned company, we should have been far more responsible. So it's really very unfortunate, and it's really sad to be hearing these sort of comments, you know, because when one is in a leadership position, you actually need to take accountability for your actions around that. And as you know, Chair, I mean, the plight of Danelle right now is very public. You know, we are losing a lot of skills in the company, and it's because of the financial challenges we find ourselves, and really it's the financial challenges that as a result of the poor leadership that we've had in place, that we're not strong enough. State capture definitely made a contribution, a significant contribution to the reputation issues that we are suffering, not only locally, but globally as well, because we operate in many countries across the globe. And also locally with our lenders, because it's made them very nervous to be associated with Denel and to be providing funding to it as one stakeholder. There's been a range of stakeholders. So coming back to the interview on ENCA, the question that I was asked at the beginning is that can I name individuals? And at that stage, because it was in a public platform and these reports were still in process, we did not disclose any names, and I did not. But the direct question I was asked, Chair, is that who was on the board of Denel Asia at the time? And that is a clear, black and white answer. So, and one could see who was on the board of the company, and that was the response I gave. And our view around the creation of Denel Asia is that it was illegal, because it was prior to receiving all of the ministerial approvals. The partner that Denel chose to partner with had no experience, and this comes out from the BDO report, in the Asian market, in particular with India. The person that was on the board of Denel Asia, representing Via Laser, one was a Mr. van der Merwe, who was a South African citizen, a lawyer by profession, and we had another individual named Mr. Singhala, and he was, at the time, he was about a 22-year individual. So he had no credibility in the Indian market, which is where they were aiming to go into. That was the one. The other is that during this era of state capture, we had also, there were some opportunities we were busy with elsewhere in the broader market of Asia. And with state capture, we were affecting the relationships we had with some of our advisors in those markets. We were sending confusing messages to our customer base. Just for the sensitivity of those countries, I wouldn't mention the names of that, Chair. So I don't know whether I answer your question.
Thank you, Mr. Sadik. Is there anything else that you want to raise with the chairperson that arises from your affidavit or the last issue that you want to add, or are you happy with completing your evidence at this stage?
I think, Chair, the one point that was raised by your legal advisor was around the interview on Morning Live on the SABC, and that was with Liana Manas at the Morning Live show. And the purpose of that interview was to discuss the contract that Danelle entered into with the government of Chad, which was to supply vehicles that were going to be used for peacekeeping services. And Danelle at the time had received 100 million rand, and we hadn't executed on the contract. So there were media reports over the weekend, and then based on that, we were then invited to be on the interview. And I, as chairman of the audit committee, I then led that interview. And the point we had made in that interview is that we had, at the time, the current board, which is I was part of, was that it was a significantly loss-making contract, and also the timeline to execute that contract was reduced by 50%. So as a result of those two, and Denel did not have the financial resources to complete the project within that specified time. And the management at the time had acted contrary to the mandate that was provided by the divisional management, who would have been responsible to execute that contract. So that was the purpose of that interview.
Thank you, Mr. Sadik. We have no further questions of this witness. Thank you, Chair.
Thank you very much, Mr. Sadik, for making yourself available to give evidence. We appreciate it, and if we need you to come back, we'll ask you. Thank you very much.
Thank you, Chair.
You are now excused.
Thank you.
Chair, I see that we've exceeded the normal time before the tea adjournment. Our next witness, I assume, is present and ready to take the witness box. May I suggest that it may be appropriate to take a brief adjournment now?
Yes, let's take the tea adjournment now. It's 11:25. Let's resume at 20:12.
20:12. Thank you, Chair.
Thank you. We adjourn.
prefer not to take.
Are you ready, Mr. Kennedy?
We are, thank you, Chair. And with your leave, may
Yes.
we now call as our next witness Mr. Abraham Stephanus Burger.
Yes, thank you. Please administer the oath of affirmation.
Please state your full names for the record.
Abraham Stephanus Berger.
Do you have any objection to taking the prescribed affirmation?
I do not have any problem.
Do you solemnly affirm that the evidence will give shall be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you, Chair. Before I ask questions of this witness, may I just mention something just for the record and for your reassurance?
Yes.
In relation to the last witness, Mr. Sadik's evidence, he
Yes.
indicated that he was willing to provide to the Commission a copy of the final Denton's report that they
Yes.
received on Tuesday. His attorney, Mr. Pillay, who's just left, has again kindly assisted us and has made available a copy already of that final report.
Okay.
So it is now already in our hands, and we will
Yes.
make the necessary arrangements to have it done through the formal channels to bring it before you,
Okay.
Chair.
No, that's fine. That's fine.
Good morning, Mr. Berger. Thank you for coming to assist the Commission.
Good morning, Mr. Kennedy. Good morning, Chair.
Good morning, Mr. Berger.
Chair, Mr. Berger's affidavit appears in Danelle Bundle 10. From page 607. Mr. Berger, you should have that bundle hopefully in front of you, and if I can ask you, please, you will know by now the references to page numbers is a reference to the top left in black ink rather than the red that you see on the right. And I'm not going to give you the full number, it's quite long, I'm just going to refer to the last three digits. So it's 607 is the beginning of your affidavit, is that correct?
I've got it. Thank you, Chair.
Right. Now, sorry, Chair. This is your main affidavit. You've also provided a supplementary affidavit. Is that right?
That's correct, Chair.
Right. Let's deal with the main one first. If I can ask you, please, to turn to the signature page on page 744.
Sorry, Chair, page 7?
744.
744. Yes, Chair.
Is that your signature at the foot?
I confirm that's my signature.
And you saw this affidavit, or affirmed this affidavit rather, in front of a commissioner whose details and signature appear on the following page, 745.
That is correct.
Now, Mr. Berger, you've mentioned to me in consultation and again this morning that there are some typographical errors in your affidavit. As I understand it, they are merely typo errors. There's no difference in substance. Is that correct?
That is absolutely correct, Chair.
Right. So you've indicated to me you don't think it's necessary for you to take the chair through every typo error, and it seems to us to be that makes sense unless the chair wants otherwise.
That is correct, Chair.
Right. Now, have you been through this affidavit? Are you familiar with its contents?
I am familiar with it, Chair.
And are you able, under the affirmation that you have now taken, to confirm that the contents of this affidavit are true and correct?
I confirm that it is true and correct, Chair.
Thank you. We'll take you in a moment to some of the points that you raised in your affidavit, but just for completeness, may I take you to the supplementary affidavit that you have provided us? Of course, the main affidavit we've seen was signed some time ago. I think that was in February, is that right?
That's correct, Chair.
And since then, is it correct that the investigators of the Commission have asked you to respond to certain questions, and in response to that, you've provided a supplementary affidavit?
No, Chair. I did respond to certain questions in my original affidavit, The second affidavit is to answer or to respond to certain Rule 3.3s that I've received.
Right. And if I can ask you please to turn to page 746.
I'm there, Chair.
Is that the first page of your supplementary affidavit?
Correct, Chair.
And if I can ask you please to turn to the signature page, 788.
I'm there, Chair.
Is that your signature?
That is my signature,
And is
Chair.
it correct that you took the affirmation before a Commissioner of Oaths as appears on page 789?
That is correct, Chair.
And that was a very recently supplied affidavit, and we thank you for your assistance. That's dated the 4th of November 2020. Is that correct?
That is correct, Chair.
Chair, at this stage, may I just apologize for a lapse on my part of professional etiquette? And that is Mr. Berger, in fact, is assisted by his legal representative, Mr. Rudy Krauser. And I do apologize to Mr. Krauser and Mr. Berger for my failure to mention to you his presence. I should have done it at the outset. I do beg your pardon.
No, that's fine. Let him just place himself on record properly.
Thank you, Mr. Chairman. My initials are RC and my surname is Krause, and no apology necessary.
Thank you very much.
Thank you, Chair. Mr. Berger, the supplementary affidavit, the same question there. Are you familiar with its contents?
I'm familiar with the Chair.
And you confirm the correctness of those contents?
I confirm the correctness.
Chair, may we then ask your leave, please, to have formally admitted into the evidence of the Commission the two affidavits. The one starts at page 607, and we would ask that that be admitted as Exhibit 25, sorry, W25.1.
The affidavit of Mr. Abraham Stefanus Berger, starting at page 607, is admitted as Exhibit W25.1.
And thank you, Chair. And may we ask that the supplementary affidavit that starts at page 746 of Bundle 10 be admitted as Exhibit W25.2.
The supplementary affidavit of Mr. Abraham Stephanus Berger, starting at page 746, is admitted as Exhibit W25.2.
Thank you, Chair. Mr. Berger, your affidavit, your main affidavit particularly, gives a very detailed account of your version. I'm obviously going to focus only on some aspects that appear to require particular attention. But you can have the assurance that the chairperson has the full affidavit and the supplementary affidavit before him, and it will, in its entirety and in its full detail, be taken into account. Your background, I believe, is summarized in your affidavit at page 618. Is that right?
That is correct.
With your leave, Chair, may I lead him on what appears to be uncontroversial aspects?
Yeah.
Thank you. You have a degree in mechanical engineering, correct?
That's correct.
And then you joined, after your academic education, you joined a company, Littleton Engineering Works, in Pretoria as an engineer, which was a subsidiary of Armscor, and that later became known as Denel.
That is correct, Chair.
So when did you first start in Danelle under its previous name?
As it stated there, Chair, LIW was Denel Lane Systems as we know it today.
Yes.
So my very first work was at Denel Lane Systems, and I've spent my entire career there.
Yes, I'm asking when did that actually start?
In 1981.
1981.
In the beginning of 1981.
So your entire career has been spent at Danelle under its previous name and then under its current name?
Correct.
And when did you leave Danelle?
I left Denel at the latter part of March 2018.
And you at that stage the Chief Executive Officer of a division of Denel known as Denel Land Systems, or DLS. Is that right?
That is correct, Chair.
And you indicate that you held that position for about 13 years before your resignation.
That is correct, Chair.
Right. Now, the affidavit deals with a number of transactions that have been of interest to the Commission, and we're going to get to some of those transactions in a moment, and particularly your own role in relation to that. Now, I'd like you to start, please, though, with the general theme, as I understand it, of your affidavit. I assume you were present earlier when Mr. Sadik gave evidence. You got here nice and early.
I was here, Chair.
Right. And you heard that I put my understanding of the overall theme of your affidavit to Mr. Sadik. But I'd like you to put the overall theme in your own words to the chairperson, if you would, please, as to your concern raised in the affidavit that Danelle has problems, but the problems have been misrepresented, as it were, as if they are all due to, or primarily due to, corruption and the involvement of the Guptas with VR Laser and the contracts that you were involved in at DLS with VR Laser. Can I let you please express in your own terms your overall feeling?
Chair, I've got a very proud history at Denel Land Systems. I was in various positions as the years went by, but in principle, in the 13 years I was as the CEO at Denel Land Systems, I inherited a business that was bankrupt at the stage. It was approximately 280 million rand turnover, and it had a huge overdraft, and it had very little order cover. We went through a process of refocusing the company. The intent of LMT had a role to play in refocusing the company. I'm sure we're gonna get to that point as well. But in principle, year-on-year growth was seen through all those years, to a point that in 2016 and 2017, the turnover of that business was just under 3 billion rand per year, and it was profitable every year. Now, that performance, in my opinion, is unprecedented. That performance does not happen by itself. It happens through people that are extremely dedicated, that are not afraid to take decisions, that think out of the box, and think like business people. Hopefully that was true for me, but I want to state it categorically that the whole team at Denel Land Systems were, in my mind, businessmen. And when they got to Denel in the mornings, they did not go to work. They went to their business. So with that as a background, I passionately felt that the decision to give a contract to VR Laser was the right decision, because I felt at the time it was the best company to do the job. Similarly, when a decision was taken to go for a single source agreement, although that was not my idea or my proposal, I supported that because, as I state elsewhere in the affidavit, the big gurus of the world that understand quality issues of complex fabrication, like Deming, said the best way to ensure a reduction in total cost is to form single source supply agreements with suppliers rather than go out on tender. So when this proposal was made to me, I only saw the benefits in that. And I supported it passionately. The point or the theme of this document is that if there were people that benefited from irregularities because of my support for those actions, I cannot stand in for that. I took a business decision, and so the overall theme of these reports were, I will not deny if I sometimes fell over my own feet in applying policies. And I stand to be corrected, and I'll take the accountability for that. But those things were all done with the best interest of the division at heart, firstly, and secondly, best interest of Denel at heart. So when anybody comes and says those decisions were made because of state capture or to enhance state capture, I really get upset about it. So the overall thread of this is we try to make good business decisions. We try to continue the growth of the business and the profitability of the business, and to the benefit of Denel. So if those decisions it misrepresented to say they were because of state capture, then I don't think it is fair, Chair. So that is more or less the theme of the document.
Right, thank you.
Yeah, before Mr. Kennedy proceeds, there is a part that I didn't hear well in your remarks, Mr. Berger. You said if there were people who benefited from decisions you made, and then you said something, I don't know whether you said you can't stand that but I didn't hear what you said.
No.
You said if there were people who benefited either from decisions you made or from irregularities or something, yes. And then you said something, then I didn't hear that part.
Yes,
have you forgotten what you said?
I cannot remember verbatim what I said, but what I meant to say was I supported business decisions. If those business decisions were in line with objectives people had that were not business decisions, I cannot stand in for that. I was unaware of anything of that nature. Okay. So I'm just trying to say that the decisions we made were purely made on the grounds of what's the best for the company and what's the best for the business.
Well, I know that you are going to give your evidence, and some of the things will come up as you proceed, but I want to raise something up front. One, the Commission doesn't operate on the basis that we want only evidence that might show that there was state capture. And we don't want evidence that might show that there was no state capture. We want all evidence that may tend to show that there was state capture and evidence that might tend to show that there was no state capture. So as a result, we want to hear from witnesses who have different perspectives about that. We want to hear, to benefit from all those perspectives. So that's the first point. But I want to say to you, in relation to state capture and what you said in your remarks, when I was hearing evidence relating to the suspensions at ESCOM a few weeks ago, one of the things I said to some of the witnesses was that it is possible that when the board of ESCOM made the decisions that it made, I don't know how much you might have followed that evidence, you might not have. Okay, I won't go into it, but when the board of ESCOM made the decisions that it made on the 11th of March 2015, which were to decide that there should be an inquiry into the affairs of ESCOM and that certain executives at ESCOM should be suspended. I said it is possible that other people outside of ESCOM had made the decision that the board should make these two decisions, should appoint or establish an inquiry and should suspend certain executives. I said that in part because, according to the evidence I had, in a meeting that happened prior to the board meeting, and a meeting that was not a board meeting in Durban, where the chairperson of the board was invited to that meeting, the issue of an inquiry at ESCOM and the suspension of executives was raised there in the presence of the chairperson of the board of ESCOM. And then I had evidence that somebody who was not part of ESCOM and was not part of government, Mr. Salim Essa, appears to, according to some evidence that I've had, appears to have known about the executives who were going to be suspended already on the 10th of March, which was before the date of the meeting. And if the evidence I've had to the effect that he knew and he told one or more of ESCOM employees the names, he got it right. You know, those were the people who were suspended the following day. I said, well, it is possible that in the board of ESCOM at that time, there may have been people who might have known about some agenda decided upon outside of ESCOM involving the suspension of the executives. But it is possible that some members of the board, in making these decisions, knew nothing about any such agenda and simply made decisions and contributed in the bona fide belief that they thought these were the decisions that were in the interest of ESCOM. And then some might have opposed these decisions, not because they knew of any agenda by people outside of ESCOM, but because on the facts, they didn't think that the decisions were the right decisions. So I'm making this example of something I've already said before to say to you, even within Denel, it may be possible that some people, if there was some agenda from people outside of Denel, it may be that some people within Denel knew, it may be that some people, other people didn't know, but believed that they were making decisions that were in the interest of Denel. But it is possible that unbeknown to them, there were people outside of Denel who may have been pushing a certain agenda that might not have been known to some people within Denel. They make certain decisions, but there are people who are pushing a certain agenda, and they believe we are just making business decisions, but actually there is an agenda that they might not be aware of, and that agenda may well be state capture. So I just thought I would mention this. I don't know if you would like to comment about this analysis.
Chair, other than that, I fully accept your point. Yes, I take your point.
Okay, Mr. Kennedy.
Thank you, Chair. Now, you indicated earlier that you are quite prepared to accept accountability if you've done something that may have been wrong, as you put it. I think you said if you tripped yourself up or fell over your own feet, I think is the expression you used, then you're quite happy to acknowledge that and be accountable for that. But it's unfair to tar you with the brush of being associated with state capture or corruption or anything. If I understood you correctly, that's your point.
100%, Chair.
Right. Now, you have also criticized, and I don't want to go into this in any detail, you've criticized the media for playing along to an agenda of trying to attach state capture, corruption type allegations to what may be legitimately explained in another way. I'd like you to just touch on an aspect that I raised at the tail end of Mr. Sadik's evidence when you were present, correct? And that is that he appeared on television, 2 television interviews, and he stated that certain actions taken were unlawful within Denel, and that criminal charges and civil claims were being brought against certain individuals. Now, you have criticized him for that as defaming you and playing along with this overall wrong, as you would see it, of trying to dress up something that you say can legitimately be explained as if it were corruption. Do you stand by that accusation?
I do, Chair. To give context, that opinion cannot be seen on its own merit. I attach a media article in my second affidavit that was written in 2016, stating various things that I've told colleagues which were blatantly untrue. And I truly believe that is where this image started. And as a matter of fact, many witnesses used that as a departure point for their opinion about me. And Chair, I don't know if we're going to get back to that article, but the fact of the matter is, if one takes cognizance of Denel Asia and the BDO report, the accusation against me was that the board of Denel only approved the concept of Denel Asia. I don't know when it was, but let's say in December of 2015. And I started interacting with potential clients or potential partners in September. That is true. I did. But I had no way of knowing what decisions were taken in the board. And whether indeed the board took a resolution or not. I was given an instruction that the board did decide to enter into this opportunity, and we should start to see if there were any business opportunities. So, and based on that, it is recommended that criminal and civil action is taken against me. sounds unfair to me, Chair. It just doesn't make sense to me in any way or term. So that is the reason for when it was then put to the into the news that I was on the board, that criminal civil action should be taken against me. I just thought it was unfair, and that's the long and the short of it, Chair.
Right, thank you. Of course, as the chairperson has indicated, he is keen, as the chairperson, to hear evidence both as to whether there was state capture, which would include allegations of corruption and wrongdoing, and also evidence whether there was not state capture and corruption, and particularly in relation to yourself and your own role. And that is why we have asked you to come and give evidence, firstly to assist the chairperson so that he can have all of the facts before him, before he writes his report and makes his findings and recommendations and submits them to the state president. But secondly, also to give you a chance, as a matter of fairness, to be able to put your version out. And as I've indicated, you've helped the Commission with a very detailed and thorough main affidavit, as well as a detailed supplementary affidavit, and all of that will be taken into account. The purpose of the hearing today is to hear you further, in addition to what is down in writing, so that you can give your own perspective and answer questions, just as we've done in relation to the other witnesses.
Thank
Now,
you, Chair.
Mr. Berger.
Maybe I can just add to this, Mr. Berger. I am particularly interested in hearing all those against whom there are serious allegations of involvement in state capture and corruption. Firstly, because my decisions and my findings would be much better if they were informed by all sides. But two, to give them an opportunity to put their side of the story openly in a forum like this. Even the Guptas, if they were willing, I would have wanted to hear their side of the story. Indeed, when I gave my judgment last year in their application for leave to cross-examine certain witnesses, I made it clear that if they were to come back into the country, I would have no hesitation in giving them an opportunity to cross-examine, if they meet the requirements of the rules, witnesses, and to hear their side of the story. So I just want to emphasize that throughout, the idea has been we must hear all sides. But if there are serious allegations of corruption or involvement in state capture against you, against certain people, I particularly want to hear their side of the story. So that applies to you.
Thank you, Chair.
Okay.
Thank you. Chair, may we just touch on an issue to get that out of the way? Likewise, before we deal with the meat of the specific transactions and so forth. Mr. Berger, you have raised your concern about the media. You've also raised your concern about some of the witnesses as distorting the facts and playing to an overall agenda of trying to dress up problems as if they were all attributable to state capture and corruption, whereas in fact they were legitimate reasons. We've dealt with that, and the chairperson has given you the assurance that he wants to hear your evidence, and it's important that he does, to hear everything. You've also criticized the investigating team of the Commission, and particularly an individual investigator, and you have alleged that you have had a perception that there was not a complete neutrality on the part of the investigator, and you felt that he acted inappropriately and in an intimidating way. Now, what I'm going to suggest to you, but subject to the guidance of the Chair, is this. The Chair has already requested, he has conveyed to me, that the investigator concerned provide a proper affidavit to deal properly and seriously with all the allegations that you've made against him personally. And we are still awaiting the affidavit. We've been told it is on the way. I don't have anything, though, to put to you at this stage as to his version. But may I say this, subject to the chair's guidance, because ultimately it is for his decision as to how this sort of matter, as with everything, needs to be handled. What I can give you as an undertaking as the legal team, subject to the direction of the chair, is that once that affidavit comes to hand, that will be furnished to you and your legal team, and you will then have an opportunity to respond to that by way of affidavit. And if the chair considers it appropriate in the interests of fairness and transparency, to hold, to give you a further opportunity to give oral evidence in that regard, and perhaps also for the investigator to give oral evidence, that will be something that the chair will consider and decide once that process of affidavits has been undertaken.
Thank you, Chair.
Would you be comfortable with that approach?
Very comfortable.
Thank you, Chair.
And I do want to say, Mr. Berger, there is nothing wrong you have done by raising your concerns about a member of the investigation team in terms of how you felt treated. So we will look into those concerns.
Thank you, Chair.
Okay.
May I also, in case there's any question mark about it, may I also, on behalf of our legal team dealing with the Denel stream, just convey to you our assurance that we have been appointed, in fact have taken an oath before the Deputy Chief Justice to act impartially and honestly and lawfully, and we have no agenda in this matter at all. And we are also concerned, just as the learned chairperson has indicated that he is concerned, we are concerned that everybody gets a fair opportunity to be heard and give their perspective. And that is why we've asked you to come today and have allocated some considerable time for you in the midst of a very busy schedule with many witnesses to give you that opportunity, which you are fully entitled to use now. Okay?
I truly appreciate it, Chair. Thank you very much.
Are you happy to proceed on that
Happy
basis?
to proceed.
Right, thank you very much. Now, you've referred in your affidavit, particularly from page 618, to what you call the general background, and I'd like to just pick up a thread which you touched on earlier, and that is the achievements that you made while at Danelle, particularly in DLS, the success, as you see it, of DLS, and then you deal on from page 619 with the present status of Danelle as a business, and you have referred to your perspective as to why Danelle, as to what extent Danelle has been suffering serious financial and other issues, and what you attribute that to. Would you just in brief terms please summarize your overall evidence in that regard?
Yes, Chair. The problems with Denel started in the early 2000s. And it started after also Denel Land Systems were very successful in promoting an artillery system in India. It went through 3 iterations of demonstration, and with each iteration, the gun had to be upgraded and modified because it was a unique system for India. Negotiating a deal in India is extraordinarily difficult, as one might imagine. We got to the point where this deal was negotiated, agreed, the contract was signed by South Africa on South African side, and it was for 280 artillery systems. Today, artillery system costs about 5.5 million. So with all the support equipment, it's in today's rand value about 30 billion rand. The biggest contract one can imagine. A single newspaper article appeared around 2003, I think it was, thereabouts, maybe two, where Denel in South Africa, where Denel was accused of wrongdoing and illegally using technical advisors. Now, I'm cognizant of the time, but it's an extremely important point because at that time, India was in the middle of general elections. The Sonia Gandhi was about to be the new Prime Minister of India, and there was a Minister of Defense. His name was George Fernandez. And when that article appeared in the papers, it was like throwing petrol on a political time bomb, and that was used as part of various allegations against Mr. George Fernandez, because he was opposing Ms. Sonia Gandhi in her campaign to win the to win the elections. She subsequently became the Prime Minister, and Denel was labeled as corrupt. It was treated as being blacklisted. It never, by the way, was proven that they were never officially blacklisted, but they were treated the whole time, and nothing was ever proven. There was no wrongdoing found, and here, 12, 13 years later, the ban is lifted. That single newspaper article, in my mind, almost broke Denel. It was necessary for government to give a bailout, and then it started to rebuild itself. But in principle, that was the biggest financial blow, because we had contracts, ammunition and anti-material weapon contracts, which were cancelled, and 30 billion rands worth of business never happened. So that is, in my mind, where the problems started with Denel. If I can then continue when after that happened, the idea was to save Denel by decentralizing the business, getting equity partners from abroad, and continuing that. And I personally felt that was the way to go for Denel. And that is when the RDM deal happened, with Rheinmetall buying into the ammunition plant. And that is when BAE Systems, the very same BAE Systems which we'll talk later on about, also made an offer to purchase the LS. And I can later get to that point. But what I thought was that was the right direction for Denel to go. And Denel, on the back of that structure, Denel started going forward and started building the foundation for a good business, getting the accountabilities at the right position, getting quick decision making, and moving forward. And that was, for me, the foundation of the growth everybody talks about in 2015, 16, that happened, 14. That's when the foundations happened. Later on, in the time frame of when Mr. Salaji joined Denel, that strategy was stopped. The idea of selling equity, the idea of having decentralized decision-making, decentralized accountability, and more centralized decision-making were taken out, and I go into my affidavit about the problems with centralized decision-making. Now, I was never really in favor of centralized decision-making because of how complex and how vastly different the processes, the clients, the technologies, and so on, of the different divisions were. There were certain divisions that were similar, and I said those divisions should be put together. But I was always a supporter of decentralized accountability and decision-making. But I've also said that if you want to centralize the business, no problem. Centralize the business, centralize decision-making, but then please also centralize accountability. You cannot have centralized decision-making and decentralized accountability. And I talk about that process, and that was my concern then with the direction the management was going. It is very interesting. I listened to Mr. Sadik this morning. It is very interesting to note that what I've now said throughout this affidavit a year ago is exactly what Denel decided to do, is now to go with decentralized decision-making, decentralized accountability, decentralized cash flow management even. And I believe that's the only way. It's a little bit late for them to take that decision, but that, I believe, was the right decision. That was, for me, the whole decentralized, the centralization model.
So sorry, before you move on from that, I'm sorry to interrupt, but it seems to be relevant for me to raise this. I can understand your frustration with an approach that didn't equate with what you saw as the best business model. The best business model, in your view, was decentralization. In other words, there would be a strong level of independence, as it were, of you as the head of DLS to be able to take decisions and so forth without having to get approval from a head office or be overridden by them. Is that right? That was a concern of yours.
Correct, Chair. But it wasn't an ego thing. It was Denel Land Systems were exporting 80% of its business. It was competing against other suppliers that were in the private industry, but which had very strong governmental support in terms of marketing and financially. And we had to compete with them, and we had to export. We were exporting about 80% of our revenue. So to compete in that arena, you've got to be quick on your feet. You cannot have a big bureaucracy which takes forever to take decisions. And a big centralized model does unfortunately do that. But that was not my criticism. My criticism really was about, if you want to centralize, then also take the accountability.
I understand your approach, and I understand your point that you felt that there was a lot of advantage to decentralize so that you can be nimble and quick and
Correct.
so forth. What I just want to ask you, though, is this. You say that your understanding of Mr. Sadik's evidence suggests that Danelle have actually eventually, after you left, have come round to your way of thinking to decentralize. What I just want you to confirm, though, is that the time that you were at DLS as its CEO, particularly around 2014 to 2016, when many of these transactions took place, it was still relatively centralized. And in terms of the company policies, the group policies, and so forth, you still had to get approval. You were finding that frustrating, not so. But you still you were still subject to a policy and rules and regulations and processes, correct?
Correct.
And you were frustrated by that?
I was.
Yeah.
I was. But those were the rules, and we played by those rules. No problem.
We're going to deal later with whether you did play by the rules, and if you didn't play by the rules, whether you accept accountability for that, and so forth. We'll give you a full opportunity on that.
Sure.
But are we in agreement then that you accepted that the more centralized model was then in force, and that applied to you whether you liked it or not.
Correct. And I was not ignoring the model.
Yes.
But Chair, sorry, I just need to add, this centralization did not happen in one go from one day to the next. It was a gradual process that started in 2013 that were running at a fairly efficient way in 2015, and from 2015 to 2018 when I left, it just was at a point where no decisions were my decisions anymore, and I recorded that it was untenable. I went through a period of 8 months of saying I cannot work under those conditions, and I left the company, resigned under the auspices of constructive dismissal. It was for me impossible to operate and be held accountable. And that's the reason. And it was a process of 8 months from where I started to say it's impossible to work like this to where I eventually just left.
Thank you. I apologized earlier for having interrupted you because I thought it was an important question I had to raise. Is there anything else that you want to add?
Sorry. On the problems.
On the overall problems.
Yes,
can I ask you, please, if you would,
quick.
If you would just please be very brief, because obviously the Commission's time is limited and it needs to focus on, in considerable detail later, on some of the individual transactions.
I will do that.
Thank you.
Okay, I'm not going to go into the very conservative and lack of decision making, which just stifles the program as a whole bundle on that. I just want to mention the LSA deal, which probably is not such a big issue, Chair, but it's the proverbial straw that in my mind broke the camel's back from a cash flow perspective.
Again, with apologies to interrupt your flow, but page 629 is where you deal with what you refer to the disaster of the LSSA acquisition.
Correct.
All right, just summarize very briefly why you call it a disaster and why you feel it was significant.
Chair, in my mind, I was part of the acquisition, the proposed acquisition of BAE wanting to buy Denel Land Systems. Denel Land Systems at the time had very strong, very huge, big opportunities, but it lacked orders. It didn't have orders, a couple of 100 million probably. And I was part of the team that negotiated with BAE, and they were very hard negotiators. And they said, you cannot expect us to pay anything for this company for a majority share if you haven't got orders. Orders determine the value of the company. And they quoted the phrase, a business without any business is not a business. And they offered more or less nothing for that business. But what they offered was, we're going to give you new business structures. We're going to put people in place that can make this place profitable, and we'll make sure you'll get orders. We'll turn the company around. The decision was taken not to go there because I think the political appetite at that stage for selling shares stopped. However, when Denel approached BAE Systems for the acquisition of LSSA, I was part of that team originally. I thought they had no orders. Why would you pay anything unless it's for strategic value for a company with no orders? Or they had 100-odd million rand orders, and they needed about 1 billion per year to sustain. So my proposal was, in recollection of what happened in the past, with BAE Systems, offer them very little. It then so happened that I wasn't part of the team, and it was bought for 855 million rand. In my view, it was too much. In my personal view, one can do due diligences, they can evaluate the strategic value of the IP, or whatever the case may be, but it didn't have orders, and I thought it was too much. Mrs. Martie Jansen van Rensburg gave evidence that said, but they had a plan to sell half of those shares for 450 million. And they were far progressed with getting potential partners in. Now, at the end of the day, the best potential partner there was for 224 million for half of the company. And for that reason, I say they paid, firstly, too much for the business. It could have at best been double the 224, the value of the company. Secondly, Denel didn't have money. And I only found out when I read Mr. Sadik's affidavit that the hoof-eisted prepayments were used to finance this deal. And no wonder we were suffering so much at the time to make ends meet. So Chair, not to go in too deep into this, I thought it was the timing was wrong to buy the place for from a financial perspective. The amount that was paid was too much, and it turned, in my opinion, it was a disaster, and it broke the camel's back in terms of cash flow management. And from that point onwards, really nothing happened in Danelle anymore, because all we were doing is speak to suppliers to beg them, please stay with us, we can't pay you.
I'd like to take you back to a remark you made earlier, which was to say it's wrong and unfair to criticize you for any involvement in state capture, and state capture wasn't the real thing, the real reason for the difficulties, and that you can be held accountable if you've tripped yourself up in relation to compliance and so forth. You're prepared to be accountable on that, but not to be accountable if you're to be criticized for being involved in anything corrupt or anything involved in state capture.
Correct, Chair.
Now, the first part of that I'd like to pursue with you. To your credit, you say you will be prepared to be accountable for anything that may have been done wrongly if you had tripped yourself up in relation to compliance of processes. As I understand it, though, your overall point that's apparent from the affidavit is that that was done with the best, if there was anything done at all, that may have been not in compliance with processes. Throughout, you had a genuine and good faith intent to advance the interests of Danelle's business and nobody else.
Correct, Chair.
Right. Now, you've been following the evidence as one would expect of the Commission. In fact, you mentioned to me when we greeted this morning that you, like we, had been up till fairly late last night. You'd seen in the media coverage of the proceedings that we finished around about 9:30 last night. You mentioned that. And so that's to your credit that you've been following with interest the evidence of other witnesses. You no doubt have heard Mr. Berger, and you've also been sent these Rule 3.3 notices to indicate that the Commission wanted you to give your answer to some of the things that have been said about you and the processes by other witnesses. You no doubt are aware that other witnesses, not all, some have defended you, but others have criticized you or your processes. You're aware that there has been evidence in the spotlight before the Commission that processes were not always followed correctly. Now, I want you, before we look at the detail of individual transactions, just to indicate so we can know upfront what your overall attitude is. Do you, in fact, say to the chairperson of the Commission now that everything you did in relation to every process for every transaction was actually compliant with every rule and requirement and regulation? Or do you say, at least with the benefit of hindsight, I acknowledge that I may have, or I did breach some particular rule or whatever, and I can explain how that came about? Which one is it?
The second one, Chair.
Right.
But I want to add, at the time we took the decision, I was not aware that I was transgressing any policy or National Treasury regulation. As time went on, I got to realize, oops, we might have done something wrong here in terms of processes. But at the time, it wasn't purposefully done to circumvent the processes. It was done in good faith at the time. But your second point that I do acknowledge, having listened to everybody, that things should have been done differently.
Yes. Could you just identify, if you're able to, without going into detail, what specifically what transaction you specifically acknowledge was not done correctly? And I accept your point, the qualification that you've added, that if you breached anything, you didn't do it intentionally. Now, that's a separate question. The Commission may or may not want to deal with that and make findings on that. But what is your own version as to what you may unintentionally have breached? For which transactions are we talking?
I think...
Or maybe, let me add this to what Mr. Kennedy says. If you are able to, you might deal with this like in 2 or 3 categories. You might say, having had some of the evidence that has been led before the Commission and maybe having read some investigation reports about things that happened at Denel, I've been able to identify the following transactions in which I was involved, where I accept that we didn't do things correctly, or I didn't do things correctly. It's this one, it's that one, it's that one. And this is where I think we went wrong. And then there may be a category where you are not sure. You say, there's this category of transactions where I accept that we may have been wrong, but I haven't reached a point where I say we were wrong, or I was wrong. And then there may be a third category where you say, on these ones, my position is clear, that I say those were in order, I didn't do anything wrong, we didn't do anything wrong. So if you are able to do them like that, that would be very helpful, but I accept that it might not be possible, in which case you just do the best you can.
Let me try and play it as it goes, Chair, if you don't mind.
Yes, no, that's fine. Yeah.
Let me start off with the first one, and that was the whole deal. And I hope we can get to the reasoning behind the whole deal, Chair. But at that time,
Which one is that one now?
The whole deal in the Hoefysterhals.
Oh, yes. Okay.
The Hoefysterhals in 2014.
Yeah.
That's. I'm sorry to interrupt. That's the platform hulls
The platform hulls.
for
yes.
the armored vehicle concerned.
Correct, Chair.
Yes,
correct.
yes.
The model was called a Berger. Is that
It's
right?
the Berger.
Right.
Berger was the product name. Hoefyster was the project name. So it's the same thing. At the time, we went out to multi-tender. The allegation today is we should have gone out to open tender. Chair, I still maintain today that in the defense industry, with confidentiality issues, with the IP issues and so on, it's very difficult, extremely difficult, if not impossible, to take something like that to the open market and publish it and say, there's a drawing, anybody wants to quote on it. How it worked is we had something which we called LIW 100. So if you are, and for you to be able to tender on something, you first have to be an accepted potential supplier. You have to sign this LIW 100, a whole lot of confidentiality agreements and so on. And then only can you get the drawings and you can sign it.
Mr. Burger, I'm sorry to interrupt, and again, I don't mean to be rude. May I suggest, so we can just bring some sort of structure to the evidence in the interest of time and focus, that we start with your identifying for each of the transactions, whether you say, following the chairperson's guidance as to which category it is. For example, when you deal with the Hull contract that was awarded by DLS to VR Laser, do you say that nothing was done wrong, or that you acknowledge that something was done wrong, or do you say in the middle category, I'm not sure? Can we just identify transaction by transaction, and then we're going to go into detail? Because may I just suggest to you why it may be in the interests of yourself, avoiding lengthy evidence and questioning from me and so forth. If at the end of a long section that you may say at the end to the chairperson, in fact, I acknowledge that this was wrong, then I don't need to go to the long process of putting to you various documents and saying, is this correct or not? If you say, I agree that I accept that unintentionally I did something wrong, then at least we know that. If, on the other hand, you say that a particular contract was awarded absolutely, it was squeaky clean, there was nothing to accept was irregular, then we know that may require a bit more detail. If there's something in the middle category, then we know that too. So if you don't mind, subject to the guidance of the chair, I'd like to start with that, and then we're going to go into the detail of each contract to the extent that we need to. Was there, in relation to the Hoefyster platform Hull's contract, what is the bottom line there? Do you accept that there was anything wrong about it, or that there was nothing wrong about it, or you're not sure?
I'll give a little bit more detail. I think when it came to the whole evaluation, my opinion was the fact that we went out on multi-tender, not open tender. I don't think there was anything wrong with that. I couldn't see any other way of doing that.
Sorry, that's for the request for offers, the three suppliers being asked to submit bids.
The three suppliers.
Instead of asking the entire nation through an advertisement in the newspaper. Right, so that was acceptable, you say?
That I think was correct. Through that process, we're going to get there, but I did inform VR Laser that their price is ridiculous. They're not serious about business, and they did submit an unsolicited offer at a time when I did not have group approval. It went through the process. It was the decided, but I thought at the time that's the only way to reduce the price. But I do accept that should not have been done. But if I did not do that, the price would have not been acceptable. I'm sure of that. So I accept that was wrong. When it comes to the single source agreement, I hope just to state the facts. As time went on, I started realizing the process, given the new legislation and the new policies at Denel, the process wasn't 100% correct. Only recently I started realizing, but there could have even been a legislative issue. But at the time, I did not know that at all. So those were the only two I think was really substantial to talk about.
And the the Denel Asia project and transaction?
I don't know. I was not involved, Chair, in the decision, in the motivation thereof, in the logic thereof, and in the final application. My legal person did support head office to write papers, but I wasn't intimately involved in that. So I don't know.
All right, let's, and there are some other transactions we may have to come back to, but I agree that these are the primary areas of focus, as will have been apparent from the evidence that the Chair and you have already heard from other witnesses. Let's go back to the Hulls, platform Hulls deal. That was, that related to 217, or perhaps a few less than that, of these particular armored vehicles. And that was a contract supplied by, those were products to be supplied by VR Laser to DLS. Is that correct?
Correct, Chair.
Right. And you have indicated that you feel there was nothing irregular about going out for simply 3 bidders rather than going out into the open marketplace. And you've said that, that you've explained the reason that the defence industry it's not appropriate to go out with this sort of product in an open tender process.
Correct,
Now,
Chair.
there are different schools of thought about that, and there could be debate about that from a legal point of view. I'm not going to spend any time on that with you.
I'm sorry, Mr. Kennedy, but I do want him to enlighten me on his thinking with regard to what he has said, namely in the defense industry, you can't go, you can't invite the whole world. Isn't the question whether the supply chain policy, the procurement policy, whether it allows you to do that or not? In other words, if the procurement policy doesn't do what you think is the way this thing should be done, you are not free to do things your own way. You must comply with the rules. So isn't the question whether it was permitted to do it that way, namely just go for certain quotations from certain identified suppliers, or whether it was not permitted?
Point taken, Chair.
Yes.
You're right. But in my mind, the Denel procurement policies allowed for multi-tender and not for open tender. So in my mind, it was allowed. Whether that was constitutionally correct, that is another matter.
Yes.
And I cannot comment on that.
Yes,
but
yes.
in my mind, it was,
Yes.
from a Denel perspective, allowed.
Okay, I take it that that must mean you had a look at Denel's policy, and there is something there that made you think it's allowed. So in other words, you can point me to specific areas in the policy to say, this is what made me think it was allowed. Or are you basing it on practice? Because I just need to know whether your view that it was allowed is based on you having applied your mind to the policy and seen something that you interpreted as allowing this, or whether it is because you know of a certain practice at Danelle that things were done in this way, and that gave you the impression that it was allowed, which may not necessarily be what the policy said.
Chair, I did not study the policy to that effect to be an expert on exactly what it says. It was my perception based on how things were done and who complained and who didn't complain. So that was my opinion at the time.
With regard to that answer, it also becomes important to establish whether there was a practice in which things were done this way, and that's part of what may have influenced your view, or whether there was no practice of doing things that way, but in your own thinking, maybe because this was defense industry, and it has certain dynamics, based on your own thinking, you thought there should be nothing wrong with doing things this way. Which one is it?
Chair, I based my opinion then and now on the fact that we should have gone out on multi-tenders. Whenever we went out on multi-tenders, it was accepted by all. And if we did not go out on multi-tender, went for single source, there needed to be very compelling reasons, or a single source agreement, or whatever the case may be. But that is, from my perspective, and speaking for myself, was influenced by how it was done and advice that I was given, and not sitting down and studying the policy myself. That I did not do.
Okay, all right, thank you.
If I can take you, Mr. Berger, to the actual SCM policy of Denel, just put aside for a moment the file that contains your affidavit, and if you just refer to the box behind you of volumes, if you can please look for Denel Bundle 1.
Mr. Kennedy, I don't know whether it might be a good idea to adjourn and you direct him to whatever you want him to read, and then he can read it during the lunch break.
Thank you, Chair.
Then when we come back, he knows exactly.
I'm happy to do that.
Is
Thank you,
that
Chair.
fine? Let's do it that way. It's about 1:30 to 1. So we will resume at 2.
Thank you, Chair.
We adjourn.
All right.
What page, Mr. Kennedy?
Mr. Burger,